Welcome back to the O'Neill Wasaki LGBT Texas Family Law webinar. This section, we are going to talk about the challenges to non-biological parents standing in custody. This is an issue that really transcends the marriage issue and the divorce issue because it doesn't really rely on people being married. It's basically when people are together and there's children involved. So, let's talk about the definition of a parent. A biological parent is obviously a person who, through biology, is related to a child. So is either the donor of the sperm or the donor of the egg biologically related to the child. Obviously, a parent is also somebody who adopts a child. Then we have some issues regarding surrogacy that are coming up and arising more and more, where a person acts as a surrogate for a baby and carries the baby. So there's some questions in the law about what paternity those women, I guess the woman would be the one carrying the baby, would have. And then we have some sperm donors issues that are arising from either formal or informal sperm donors that as to their paternity, their relationship to the child. And then later in the presentation, we're going to talk about the non-parent, so people who are not legally under one of those definitions a parent, but who emotionally feel like they're a parent and have been around the child and involved as if they're a parent, and what rights to the child that they may or may not have going forward. I'm joined today, my name is Michelle O'Neill with O'Neill Wasaki. I'm joined today by Karri Bertrand and
Hello.
Nick Rodriguez, both attorneys in our firm, and they're going to help me present this topic to you guys in this webinar. So let's just jump on in here. There was a recent case about a donor as a parent, Nick, and so I think that's In Re PS.
Yes.
We were talking about before we went on camera that it's really hard to talk about these cases because the courts of appeals have a policy that if a child is involved in the case, that the case goes by initials to protect the child's identity. So all these cases that we're talking about are all initials. So they're somewhat hard to kind of keep straight. But we'll post sites in the comments as we're going along so that you can follow and read the cases if you want to yourself. All right, so talk to me about In Re PS. Tell me what happened in that case.
Okay, so we actually wrote about this in our blog, Gay Parenting Dallas.
And we will post a link in the comments to the blog post.
Shameless plug. But yeah, so so in this case, in Re PS, a woman asked her friend to be a sperm donor. They'd known each other for several years, and so she, requested, to obtain his sperm. The woman actually ended up getting the sperm directly from her friend, known sperm donor. There was actually an acknowledgement of paternity that they both filed, and then bio mom ended up trying to rescind that acknowledgement of paternity once a child was conceived and born. So the way it ended up was, mom ended up having a relationship with a woman later, soon after, that relationship, or she tried to have a second parent adoption with, her partner.
Yeah.
Sorry, thank you for that. And so when she attempted to do that, the father at the time was claiming paternity to the child. And so the court rested its decision on two statutory provisions found in the Family Code. So they're found in section 16702, which states that a donor in Texas is not the parent of a child conceived by means of assisted reproduction. The court went a step further and looked at the definition of what a donor actually is. And so that by definition, a donor in Texas, to be considered a donor in Texas, an individual had to provide sperm to a licensed physician to be used for assisted reproduction. And so because the mother received the sperm initially directly and she artificially inseminated herself and it wasn't performed by a licensed physician, the father was deemed to have parental rights to the child and therefore her partner could not, perform or have a second parent adoption.
Okay, so the lessons from NRA PS and based on the statute. What's the statutory reference again for those who missed it?
So section 160.702, it defines, who can be a donor, and then 160.1026 defines a donor, and then 160.702 states if you are a donor, what your parental rights are.
Okay. All right. So, so a donor then under Texas law and under the PS case, what court of appeals is PS out of? Do we know?
I believe the San Antonio Courts of
All
Donor.
right. So a donor under Texas law then is somebody that provides sperm through a licensed clinic or a doctor.
Correct.
So if you just, get some sperm from your friend next door, that is not technically a donor under Texas law.
Correct.
All right. So if we were advising people that wanted to get pregnant through a donor, I guess we would need to advise them that if they don't intend for the donor to be a parent, they need to go through a facility, go through a doctor.
Have a donor agreement.
Yeah. Well, it sounds like even under PS, even if you had a donor, I guess PS doesn't really address the concept that if they had an informal donation and a donor agreement that provided he wasn't a father, it doesn't really address whether or not that would be a donor under the Texas law or not.
Bottom line, don't do this at home. Yeah. No turkey basters.
Yeah, so don't try this at home.
Pretty recent, 2016. It was not too long ago that the court ruled this. So
yeah. So, all right. So a donor then is a person who donates through a facility as opposed to an informal relationship. Does it matter, Karri? Let's set up an example or a scenario kind of to talk about the next group of cases. So you have a couple, same-sex couple, that let's make them a lesbian couple because there's some differences in female biology as far as having children.
Right.
So a lesbian couple is together, and one of the women decides to get pregnant, presumably through a donor, and we'll assume that they're going through a facility for this presumption, so we don't have these other paternity issues. And so let's talk about the child that is born to one of the women, and who are the parents of that child based on their relationship. So if they're married, well, let's start with unmarried. That's an easier question, right? if the lesbian couple is not married and one of the women gives birth to a child from her body during the relationship, what is the other person in the couple?
We're not married, right?
Let's say not married first. Sorry.
Not married. Only biomom is going to be a parent if they are not married.
So the other person in the relationship is not legally related to the child.
Correct.
If they are married at the time that the biomom gives birth to the child, what does that do here?
It depends.
Yeah, we don't know.
No. Yeah. There seems to be splits in the courts of appeal. Some are saying that they need to still adopt. So the presumption of maternity of a child born during a marriage of two females is not being uniformly applied.
So let's talk about, just for reference purposes, if it were a heterosexual couple. Obviously, a child born to a heterosexual couple during a marriage is the father is presumed to be the parent of the child. That's the presumption of paternity that's found in the Texas Family Code, right?
Correct.
So what we're talking about then is what presumptions of parentage apply whenever you have a same-sex couple. So you have a same-sex lesbian couple, one spouse gives actual birth to a child during the marriage from a donor, and the other spouse, the question is, are they or are they not a presumed parent? Obviously, she wouldn't be a biological parent, but would she be a presumed parent under the law? So, Karri, help us walk through what the statutes are that we might want to look at in analyzing this question.
So under the Family Code, Section 16204, which is the presumption of paternity.
Of paternity.
Paternity, correct. A man is presumed to be the father of the child if he's married to the mother of the child and the child is born during the marriage. He's married to the mother of the child and the child is born before the 301st day after the date of the marriage is terminated by death, annulment, declaration, or invalidity of divorce. I don't think Michelle really wants me to read the whole statute to y'all. Basically,
Read the statute on your own, 160.204.
you can go through the various prongs of the statute. Basically, though, if you flip over to the page before that, Section 160.106, before we even get to the presumption of paternity, it states that provisions of this chapter relating to the determination of paternity apply to determination of maternity. So
the logic then is combining 160.106 with 160.204, there's an argument to be had that the presumption of paternity that applies to a man who is married to the mother at the time the child is born would also apply to a woman who is married to the mother at the time the child is born.
correct.
And then when you read on down in 204, there's also some kind of other interesting provisions of presumption of paternity.
Yes.
Like number 5
Yes.
says, during the first 2 years of the child's life, he continuously resided in the household in which the child resided, and he represented to others that the child was his own. And so if a man can do that for the first 2 years of the child's life, basically represent himself to be the father and therefore be presumed to be the parent, then 160.106 would imply that a woman could also do that.
Correct.
Have there been any cases that have talked about the application of these statutes at this point?
One of the more recent ones that we also blogged about that we'll post the link to was one out of San Antonio called NRA NMB. Now, the facts in this one are a little bit different because the couple broke up before the child was born. And one of the biological mother moved to Texas. And after she moved to Texas and the child was born, she basically attempted to cut off the other parent or her former partner's any rights to that child. Non-bio mom filed a lawsuit here in Texas trying to establish standing. And she tried to establish standing under a couple of different provisions of the statute, including the presumption of maternity. And this court said no. This court in NRAE said the presumption of paternity does not apply to women, and it refused to extend the constellation of rights under that presumption to lesbian couples, and basically said, Obergefell acknowledges that state-derived benefits of marriage that a state may confer upon married couples, including adoption rights and rights of child custody, support, and visitation rules. None of these state-derived benefits of marriage are fundamental rights. And I think it's still being considered for review at the Supreme Court of Texas.
So you're talking
level.
about AE. You started talking about NMB, I think.
Oh, I'm
So
sorry.
We got. I think we flipped
switched
cases
over.
on us.
I did.
Yeah.
I'm sorry.
Okay, so let's talk about NMB for just a
Yes.
minute, and then we'll switch over and talk in detail about AE. So NMB, what do we know what court it was out of? I think it was San
Antonio.
Antonio. So the same court that PS
Yes.
was out of.
Yes.
And so what was NMB about?
We had the parents, the child was born before, and then they split up. Actually, it was born after they'd split up, and the mom moved here, and the non-bio mom attempted to get standing to get rights, custody rights to the child, and was denied standing.
All right, and so what did the San Antonio court in the NMB case say?
They did not apply the presumption of paternity because it doesn't apply to mothers. And they're looking at the statutory construction under the Uniform Parenting Act and saying that this is only meant to be for men and fathers.
Okay, so then let's switch over to AE because that's so important to our discussion about standing and non-bio parent rights here. So talk to me about AE. What court is AE out of? Do we know?
Yes, we should know.
Well, we'll look that up and put
Beaumont.
it in the, okay. I was thinking it was Beaumont, but I wasn't going to say it because I might have been wrong. Yeah,
Jump in, Nick.
Jump in, Nick.
Help me out.
All right, so AE comes out of the Beaumont Court of Appeals, and so tell us about AE.
So, as I kind of jumped ahead and started telling you, it's a similar situation where you have a married lesbian couple separating prior to the birth of the child. And in this case, same kind of issue. The parent tried to get standing to have custody rights, and the court refused to apply the presumption of maternity to the presumption of, or the maternity to the paternity statute. And I don't know really. I look at the family code. I see, this is what it says. The courts are looking at it and say, no, that's not true. It's only men. So I don't know how going forward the Supreme Court will look at this, because it is being considered for review. And I know there's a lot of agencies looking at this case nationally to see kind of going forward what Texas does with this, because I think this is something that needs to be fixed.
So AE is currently pending before the Texas Supreme Court right now.
They denied review initially, and then but it was just the en banc review. What is it?
Yeah, well, so they denied review, and then they have, I think there's been a motion to reconsider filed.
Yes, that's probably
and
what
so
it
that's
was.
still pending at this
Yes.
point. Okay, so let's walk through standing. So if there's a person who is not legally a parent to a child, and they have been in a relationship with the parent of the child, and really this applies actually to some heterosexual couples as well as same-sex couples, right? It's not necessarily just a gay rights issue, but if there's a person who has been in the home in part of a relationship with a parent, and that relationship is breaking up, then is there ever a time where such a person would have a right to sue, standing to sue, for rights to the child?
Yes.
So under 102.003, that's where we talk about standing. So Nick, tell me the difference between standing and winning your case.
Standing and winning your case.
Yeah.
Well, standing is obviously a procedural issue that needs to be resolved first before you can even have a case.
Right.
So, I mean, if you don't meet the requirements of standing, there's no case to be had.
I like to think of it as standing is the right to walk in the door to the courtroom.
Foot in the door.
Yeah.
Yeah, it's the foot in the door. That it doesn't mean that you're going to win your case. It doesn't mean you even have a case on the merits. It's just the right to be in the courtroom. And I think that's a real important distinction in these cases, and we'll talk about that in detail here, that just because you have standing to sue doesn't mean you actually have the merits of a lawsuit to prevail. And that's I can't stress to you enough how important that is in evaluating these cases like this for a non-biological parent suing. All right, so let's talk about it. 102.003, subsection A9 says that an original suit may be filed at any time, and then 9 says by a person other than a foster parent who has had actual care, control, and possession of the child for at least 6 months, ending not more than 90 days preceding the date of filing of the petition. So the key words there then are actual care, control, and possession of the child for at least 6 months, not ending in more than 90 days. So the first takeaway to me from just reading the statute is that in advising clients, we have to advise them to act fast. In other words, if you think that the relationship is breaking up and you might want to sue for some continuing relationship with a child that is not biologically or adoptive your own, then you need to act fast because you have a short little window of time to seek relief under this statute. So you have to file, so you have to have had actual care, control, and possession of the child for at least 6 months, ending not more than 90 days before the filing of the petition. A lot of times what we see is when these people break up, the biological parent will withhold the child from the other person almost immediately. There are other situations where the biological parent will maybe allow some access for a small period of time going forward and then revoke the access. And those are the cases where, those are the situations where this can actually be quite problematic. Yes. Because if you break up and you separate and you still have some access for a while going forward, but the parent, the biological parent, is in control, there's that word, control, of what that access is, and then, 6 months down the road, the parent revokes that access, then that's kind of where you get into some really murky waters where you may have waited too long to seek relief, right?
And that happened in NMB. The court looked at the issue of equitable tolling because one of the things that the non-bio mom claimed is that they were trying to work out an agreement. She's letting her see the kid and then not letting, and the court's like, sorry, you no longer had actual care, control, and possession.
So I was fortunate to be involved in one of the very first cases on the question of the application of the standing to sue under actual care, control, and possession to a non-biological lesbian mom, emotional mom. And that case is in Ray MKSV. And that was actually the case of first impression when it came out many years ago, that held that a non-biological lesbian mother could qualify under this statute to have standing to sue for conservatorship or custody of a child. So in that case, they had broken up, and it actually deals with that equitable tolling question as well. So in MKSV, they had actually broken up and operated by a written agreement under what family lawyers would call basically a standard possession schedule. They had a whole schedule. It very much mirrored the statutory every other weekend, 30 days in the summer, split up the holidays kind of schedule. And they operated by that for quite a long time. And then all of a sudden, the biological mother changed her mind and revoked her agreement and started denying possession. And so thankfully, my client filed within that 90-day window of not having seen the child according to their agreement. So in MKSV, they had the equitable tolling question as well as the ultimate standing question. Right. So in MKSV, the Dallas Court of Appeals held that my client had actual care, control, and possession at the acquiescence of the biological parent, sufficient to meet the standing statute. Unfortunately, the rest of the story in MKSV is not so happy, because it illustrates this problem of getting standing to sue is just the very first getting the foot in the door versus actually prevailing. So the rest of the story is that the Troxel is a US Supreme Court case that ruled that a parent has a constitutional right to parent without intervention from the government or anybody else, unless that parent is shown to be unfit. So when we're talking about this standing to sue issue, the question isn't just a question of standing. Standing's just the initial problem. But the question then becomes, do you have enough to actually win your case? And in MKSV, both of these ladies were good people and, for all intents and purposes, good parents. And so we did not have enough to meet the Troxel standard. And so we ended up actually non-suiting MKSV because we did not feel that we could meet the Troxel standard. So that's quite a problem.
Yes. There's
been a lot of litigation over the definition of the words care, control, and possession. So possession is a fairly well-defined term. I mean, it's a term that kind of connotates. It was a term they talked about in MKSV. It was decided on the term possession, and they found that the agreement between the parties that was something similar to a standard possession schedule was along the lines of possession as it's termed in the standing statute. The words actual care is also somewhat obvious. Are you caring for the child independently? Is the child staying at your house, sleeping, whatever? Are you taking the child to the doctor? Are you taking the child to school? Are you doing homework? Those are the terms that care would connotate. But getting back to AE. In the term control, right? The term control has been quite litigated. So where are we at in this control issue, Karri?
As far as which child is the parent living with, or?
Well, in terms of standing and the control understanding, so there's been some recent cases that have defined control and have allowed control to be to include kind of the idea that a non-biological parent, when they have the child, even if the biological parent is letting them have the child, that is a term of control. So the Texas Supreme Court decided a case recently on this control issue and actually held it to be a little bit broader than what some of the courts of appeals have held it to be. So so there was a split in the courts of appeals. Some of the courts of appeals were defining the word control very narrowly, and some of them were defining the word control a little more broadly. And so the last summer, the Texas Supreme Court came out and said, basically resolved this dispute to say we're defining it in the more broad sense of the term instead of the more narrow sense, which actually gives these non-biological parents a little bit more of a foot in the door under the definition of the word control.
The NRA H&S case, I think,
Yeah.
right, where there was no voluntary relinquishment, I think, of one parent living with the grandparent or something.
Right, and that's the question, is whether they're allowing this access, whether that's allowing control, or whether that's actually the biological parent exercising control.
Right.
So let's talk about Troxel for just a minute. We're cutting close on time here. So Troxel basically is the U.S. Supreme Court case that kind of predates a lot of what's in our statutory scheme that says that a fit parent has a constitutional right to parent without intervention. So that raises the standard for intervention, whether it's Child Protective Services, whether it's a non-biological parent, grandparent, boyfriend, girlfriend, step-parent, or anybody else for that matter, to intervene in a suit or to file suit over custody of a child. So there's actually this really high burden that you have to prove in order to prevail on the merits of a custody case. And it basically equates to there really is no lawsuit for sub-parent rights. In other words, there's no lawsuit for access. There's no lawsuit for a standard possession schedule. You have to either sue for primary custody and allege that the biological parent is unfit, or you can't win, right? And I mean, that's really hard. What do you advise clients whenever you're talking to clients about that?
I mean, that's frustrating because they're not necessarily looking to destroy the other parent. They're not necessarily looking to say the other parent is unfit. They just want to have a part of their, be a part of their child's life. And so, you're kind of stuck in this place where you're walking away. Like, I think that's what happened with your client in MKSV. You're having to walk away from years and years of litigation and maybe never being able to prove, the standard, that high burden, or
going through mudslinging litigation.
Constant mudslinging litigation.
We see it more in grandparent cases. We see more of the grandparents intervening because maybe a parent or both parents withdraw access for some family feud or whatever.
Right.
But you see it more in grandparent cases, really is where we see the litigation on this issue coming about. And there is a special statute for grandparent access, but it even still carries this high burden
Right.
of proving some reason that the parents can't make decisions about their own children, right? So what do you advise a client, a person who comes in, let's say that for some reason they actually came in early in the process, they're still in the relationship, maybe the relationship is rocky, but they know they're not legally a parent. What do you advise that person to do, first and foremost?
Preserve that right immediately. I think you get your foot in the door and preserve the standing issue. And then I think if you can't meet that high burden, which many of these cases won't, I think you try to get to mediation. You try to reach an agreement to where.
Well, and I would actually say adoption. Like if they're still together and there's still an opportunity to keep the relationship intact with the biological parent, what I would say is try to reconcile that relationship and push for adoption as a part of that reconciliation so that you are legally a parent.
Very
So for me, like the first thing that I talk to people about whenever they're in that situation is adoption.
Right.
And I wish, and hopefully our presentation today will kind of help some people who are maybe in the beginnings of a relationship and maybe looking at having children in a same-sex relationship, and help them to make those decisions early on to do an adoption. With lesbian couples, like we said, where one parent is actually giving birth, then you have to do the other parent's adoption to make sure that that's as safe as we can get it. With men, it's actually a little bit different because obviously a man doesn't give birth, so usually those are surrogate women that are giving birth for the man or adoption.
And it's extremely expensive.
Right.
Also.
And so, like, if two gay guys were adopting a child, then it would be fairly common for both of them to adopt now because they're allowed to, right?
Yes.
But there have been times in the past where they weren't both allowed to adopt.
Well, I believe Texas doesn't. I think Texas allows a single gay man to petition for adoption. I think there is case law that says a married couple, same-sex couple,
They have to be married, yeah.
can petition for adopt
For
a
both
child.
of them to adopt, right?
So I don't know if Texas explicitly states that they can both petition to adopt.
Well, I think under Obergefell, I think if they're married, they do get to do that. We're also finding that where, like with a lesbian couple, where one woman gives birth to a child and is married to her partner, actually the Bureau of Vital Statistics is allowing them to file the birth certificate with the married partner's name as the other parent. Now, the problem with that is that I think it's still not a presumption, as we've talked about under the code, even if it is under the statute. So we're still recommending some court acknowledgement of that parentage of the non-biological parent, even if the Bureau of Vital Statistics is allowing them to be listed on the birth certificate. So either a declaratory judgment action or an adoption of some sort that actually solidifies that parental relationship, even though they're on the birth certificate. And then, so if you have a client who's coming in with, we've broken up, I want to try to preserve my relationship. Like you said, settlement is the best way because then you have that court order giving as if it's parental rights or non-parental rights to the child by court order. And that actually lets them maintain those rights going forward, right? In other words, it can't be taken away.
Right.
And so if they are named a conservator, then they can be a conservator and they can sue to modify those rights in the future if something changes and get more access, say, for example. So settlement, even if it's a less than ideal settlement, is the best way to go just to get the foot in the door and maintain the relationship, right?
Agreed.
All right, I think we have reached our end of our session 2. So we're going to take a break here. And we'll come back in a few minutes and go to our session 3, which is addressing prejudice against gay and lesbian issues in courts. All right, we'll be back in a minute. Keep in mind that this is a webinar that's aimed at attorneys. This is for continuing legal education. If you're out there watching this webinar and you're not an attorney, we welcome you to watch it. But remember that we are not giving you any specific legal advice. We cannot comment on any specific case or situation without knowing all the facts. So if you need legal advice, this webinar is not a substitute for legal advice. Please seek the advice of a lawyer as to your specific situation and get specific advice to that. Because if you rely on just what we're talking about here, we're being general, we're talking about general legal principles that may not actually apply to your situation. This is for continuing legal education only, and we cannot create an attorney-client relationship just through the video camera. Okay? Thanks.